When is DWI a felony in Texas? I'm Jeff Hampton. Thanks for joining us here at the Fulgham Law Firm for our video series here about DWI. Thanks for joining our YouTube channel as well. And today I want to go over a question I get all the time. People call me and say, hey, when do I know, how do you know whether a DWI is going to be charged as a felony or a misdemeanor? And so today the goal is, let's go through the ins and outs of basic DWI law in Texas. Now, I'm not going to go do a deep dive on each and every one of these individual DWI crimes, but I want to give you kind of a bird's eye view of what the law says about these so that you have a general idea of what to expect. And then we'll have future videos that we'll continue to put out where we'll go into more depth in each and every one of these if that situation applies to you, okay? And by the way, if you wait around till the end of this video, I will provide you a free ebook, The Ultimate DWI, The Ultimate Guide to Your DWI Defense in Texas, all right? We'll get that to you at the end of this video. Now, let's talk about this for a second. Now, generally, driving while intoxicated, listen, if you're charged with a DWI, it'll change your life. If you're convicted of a DWI, it can affect you in so many ways. If you're convicted, you could end up doing jail time. You could have probationary periods. You could have up to 2 years on a misdemeanor, up to 10 years on a felony. You could have a suspension of your driver's license for up to 2 years, not to mention the long-term consequences of what a DWI conviction could do on your criminal record. But when DWI is charged as a felony-level offense, these consequences are much more severe. You could be talking literally, depending upon the nature of the charge, you could be talking about up to 20 years in prison, very serious charges. So we want to look at this and identify it and know the difference between a misdemeanor DWI and a felony DWI and what to be aware of, okay? Now, generally, we're talking about felony-level DWIs. Generally, you can have anywhere from a lower-level felony, state jail felony, all the way up to an intoxication manslaughter, where you can go from a state jail felony all the way up to a much more serious felony offense. So let's identify that. Number one, let's look at intoxication assault. Intoxication assault, if you're involved in a motor vehicle accident, let's say that they're able to prove beyond a reasonable doubt, the state of Texas can prove that you were intoxicated, operating a motor vehicle and intoxicated in a public place on the roadways of Texas. And if you injure another motorist or a pedestrian while driving while intoxicated, you could be charged with the third-degree felony of intoxication assault. So what does that mean? Well, intoxication assault could be punishable by anywhere between 2 to 10 years in prison or up to a $10,000 fine. So we'll do a deep dive on that on some other videos, but I want to first identify intoxication assault. Number two, what about intoxication manslaughter? Well, intoxication manslaughter sounds like about what you think it is. If you are driving while intoxicated, you are in a public place, and if it can be shown that another motorist or pedestrian was killed during that driving while intoxicated, you can be charged with an intoxication manslaughter. Now, that is a second-degree felony. So a second-degree felony punishable by anywhere between 2 years all the way up to 20 years in prison and up to a $10,000 fine. Now, I would do a separate video on this, but one of the biggest issues for intoxication manslaughter is causation. They must show, the state of Texas must prove beyond a reasonable doubt that the actual intoxication was the cause of the death of another person, okay? Now, what about our next one? Our third offense is DWI with a child passenger. So if you are carrying a child passenger under the age of 15 when you were arrested, let's say they believe you're driving while intoxicated and you're pulled over, and they can, if the state of Texas is able to prove that you are intoxicated and you have a child in your car, that is now considered a state jail felony, punishable by a minimum of 6 months in prison all the way up to 2 years. Now, I say prison, it's actually called a state jail facility, okay? It's still a felony, though. It's 6 months to 2 years and up to a $10,000 fine. Now, the next option is what's called DWI third or more. Now, this was pretty simple. If you have previously been convicted of 2 DWIs and you pick up your third or fourth or fifth DWI, doesn't matter where you're from. I mean, literally from anywhere else in the country, that will now be treated as a third-degree felony. So if the state of Texas can prove a regular DWI, but you've had at least 2 of these on your record from the past, that is now a minimum of 2 years, up to a maximum of 10 years in prison, and up to a $10,000 fine. Just a quick little example here. We represented somebody one time that was up in Boston, and in Massachusetts, the laws are totally different. You can get several DWIs, and they're just like citations. And he had already had 3 DWIs from Massachusetts, moved here because he worked in an investment firm, moved here and picked up a DWI and was shocked to find out this was now treated as his 4th DWI, and it was 2 to 10 years in prison, and we had to fight that case. And so my point is, it doesn't matter where in the country you received any other DWIs, if the government, if the prosecutor can get proof of those judgment and sentences to show that you had taken a plea deal, they can enhance a regular DWI up to a felony DWI. Very important to know that, okay? Finally, let's say for some reason you have a loved one that has a prior felony conviction. Maybe they've been to the Texas Department of Corrections in the past and they pick up a new felony DWI. That can actually be enhanced to a higher level offense. It can be enhanced from a 3rd-degree felony up to a 2nd degree because prior penitentiary trips can allow that to be an enhanced charge with greater punishment. Finally, I'm just going to tell you this. You say, okay, Jeff, you've told me what the felony DWIs are. What are the misdemeanors? Well, what about just a good old-fashioned first-time DWI? Now, if you just take up a first-time DWI, that is a Class B misdemeanor, punishable by up to 180 days in jail and up to a $2,000 fine. And then if it's a second DWI, which is called a DWI misdemeanor repetition, that is a Class A misdemeanor, punishable by up to a year in county jail and up to a $4,000 fine. And then they created this new little crime they called DWI with blood alcohol over 0.15. So even if it's your first DWI, the state legislature just kind of drew a little line in the sand arbitrarily and said, if you're over 0.15, we're going to treat it more severely. And now you're going to end up having to do a Class A misdemeanor, charged with a Class A misdemeanor, up to a year in county jail and up to a $4,000 fine. So why does all that matter? Well, listen, there are unique defenses for each and every one of these. In general, the state of Texas must always prove that you operated a motor vehicle in a public place while intoxicated, okay? So you can imagine the while intoxicated. That means, what does that mean? What's the definition there? Did you lose the normal use of your mental faculties or your physical faculties by reason of the introduction of alcohol or drugs into your body? And then number 3, 0.08. We all know the 0.08 language, right? So if you have a blood alcohol level over 0.08, that is the way that the state of Texas will try to attack most DWI cases. Now, maybe you're facing a DWI case. You or a loved one, maybe you have more questions, and maybe your case is in the North Texas area. Don't hesitate to contact the Fulgham Law Firm at 817-877-3030.